Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, for those of you who geek out on the channel all the time, you might recall that we did this video about this ridiculous lawsuit that the city of Chicago was bringing against the Glock firearm company. That lawsuit eventually just died because it was absolutely going nowhere, and we kind of thought that would be the end of the insanity. Well, then, of course, along comes Attorney General Matthew Platkin of the great state of New Jersey and files yet a similar lawsuit. But I got to be honest with you, I had a chance to go through the complaint because one of the things that I wanted to see is this the same old, or is Attorney General Platkin claiming something different? And he is claiming things a little bit differently, and the allegations are more salacious if they were true or if they even mattered. So today, let's spend a few minutes and let's talk about, so now New Jersey is suing Glock. Okay, hey, before we get going too far down the road we're going down, let's remember that this video is being brought to you by the good folks at the Sonoran Desert Institute. That's right, get ready to arm yourself with education today. Get ready to start defending the inalienable rights of millions of Americans nationwide. And most importantly, get ready to launch your career in the firearm industry today. Listen, the Sonoran Desert Institute has a program, degree, or certificate for just about anything that you may desire. So for more information, check them out in the description box below, or easier yet, just visit them at sti.edu. Okay, America, the case we're talking about today is a newly filed civil act entitled Matthew J. Platkin v. Glock Inc. This is a suit that's brought by New Jersey's Attorney General, Matthew Platkin, against Glock because apparently Glock has been complicit in the design and use of illegal Glock switches, and therefore Glock should be held liable for the illegal activities of everybody else. Now, I was originally going to kind of go through the pleadings here, but then I just had a geek out session with the Hannah Hill from the National Foundation for Gun Rights, and we were talking about this case, and as we were brainstorming through it, I really kind of thought, well, you know, this is actually probably a little bit better angle to take. Now, if you may recall, the city of Chicago tried this stunt just a few months ago, and we did a couple of videos on it. We talked about how dangerous it was, but ultimately the city of Chicago chose to dismiss this lawsuit. Interestingly, the judge that they had been assigned to was notoriously pretty good on Second Amendment issues, so that may have something to do with it. So what we may have here is just the revision of another lawsuit through an act that attorneys know called forum shopping. Can we get it into a more favorable jurisdiction? And certainly when it comes to Second Amendment cases, New Jersey has never carved out a reputation of being really strong on that issue. The interesting thing, though, when I had an opportunity to sit down and I read the Chicago complaint and now I read the New Jersey complaint, the interesting thing is that in the New Jersey complaint, there is significantly more salacious allegations. And this is what I mean by that. There is allegations in this complaint that Gaston Glock and the original designer of the Glock switch worked complicit with each other to ensure that these devices were going to be put into mass circulation, okay? And I'm going to read to you the portions of that complaint. Now, two things. Let's just assume that to be the case in arguendo, okay? Be that as it may not matter at all, because as we know, and we've been talking about this huge piece of federal legislation in the case of Smith & Wesson versus Mexico, which is the Protection of Lawful Commerce in Arms Act. And even though we can do a whole 25, 30-minute video on that, let me try to sum it up to you in really, really simple English. What it basically says is, hey, listen, you can't sue firearms manufacturers for the illegal activity of third parties. In a civil context, we would call that a superseding, intervening cause that, because it was illegal in nature, would not be as foreseeable as things that should or should not be happening. Now, in the complaint, there is a long recitation of events about how when Glock released its first real popular polymer 9mm handgun, which of course is the Glock 17, there were militaries in Western Europe that wanted an automatic version of it. And therefore, Glock developed the Glock 18. I did not even know if there was such thing as a Glock 18. I had to go look it up. Never heard of it. What is the Glock 18? Well, the Glock 18 is basically a Glock 17 that has a full auto setting to it. Now, that was done using the exact same technology that later is being used in the Glock switches to also mimic full auto fire. But then the Attorney General makes these allegations contemporaneous with the time frame in which the Glock 18 was going into production. Around the time that the G18 went to market, Jorge Leon, a 22-year-old Venezuelan inventor, began studying the firing mechanism of the G17. A government agency in Venezuela had indicated that the G17 would be more desirable to procure if it possessed an external safety against accidental discharge. Leon set out to design and market such safety in response. While working on that project, Leon realized that if he inserted a small external component through the G17's removable backplate, he could cause the G17's trigger bar to remain lowered after a pull of the trigger until the trigger was released. This enabled the G17 to fire automatically, functioning as a handheld machine gun. Though this result was not the safety function sought by the Venezuelan government, Leon believed that there could be a market for this type of simple add-on component too. Oh, but then the allegations get more salacious than that, because the New Jersey Attorney General also claims at a Caracas shooting gallery in the presence of Berger, Venezuelan military and police officials, and Leon, Gaston Glock fired and demonstrated the G17. He then took a small prototype switch from his pocket, detached the gun's backplate, and affixed that switch to his gun. Gaston Glock raised the gun again and fired it as a handheld machine gun in bursts of automatic fire. And the complaint also states, years later, Leon successfully applied to patent his design for the fire selector system for Glock FSS/G. His patent application described his invention in nearly the exact same terms that Glock used to describe the G18. Leon was awarded his patent in 1998 and marketed it to military and law enforcement customers. But again, all of this is still completely legal activity, which apparently is being developed for military and law enforcement applications. Oh, and by the way, the source for a majority of that allegation, an article in the New York Times. So, take that for what it's worth. But this brings us full circle to why we have the Protect Lawful Commerce in Arms Act, a piece of legislation which was absolutely positively passed for this exact purpose. Now, the reason Attorney General Platkin's making a big deal about it is if all of these allegations were true, and Gaston Glock really did want to develop a semi-automatic firearm, which he knew then could be readily converted into a fully automatic firearm, and that was his goal all along, could there be a piercing of the PLCAA under some of the exceptions to the statute? There most certainly could. The likelihood that these allegations are going to be substantiated, however, is pretty remote. But then again, there probably is a reason by which the Chicago suit was dismissed and the New Jersey suit was now refiled with more salacious allegations, for the simple reason that there may be a much more receptive forum to which to argue it in front of. Oh, and on a little side note, they make a big deal out of how the Gen 5 models are a little bit harder to do it on, but Gen 3 and Gen 4 models still remain readily available in marketplaces throughout the United States. They should probably take a look at the approved handgun rosters in some of those states where the Gen 3s and Gen 4s have been grandfathered in, but the Gen 5s have not. I mean, after all, don't you think the gun stores and the Glock company itself would rather sell its newest and therefore most expensive version of their firearms? But listen, I want you all to be aware that what the Attorney General is arguing here is that Glock, in its design of handguns, is making a firearm that is readily restorable or convertible to an automatic weapon, which now places it under the federal definitions, arguably, of what is an unlawful machine gun. And this is an argument that, if successful, will grow like wildfire into other areas, other states, and other arguments, all designed to actually run the Glock manufacturing company completely out of business in the United States. Okay, the case once again is Matthew J. Platkin versus Glock Inc. We'll link up the complaint down below so that you can geek out on it for yourself. Bring a barf bag. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing around here, cool. Tell us all about it by clicking on that link right there. If you just want to subscribe to our monthly newsletter, the ability to do all of that is right down there in the description box. And then finally, and most importantly, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.